Okay, it's 1 o'clock. We'll go ahead and get started. Welcome to our webinar, Trucking Companies, AB5 has arrived, what now? Before we get started, this webinar is being recorded, and we'll move on to the next screen to give everyone a few moments just to read the legal disclosure on the screen. Okay, next slide. So my name is Catherine McLean. I'm the VP of Strategic Marketing and Communications for Transforce. Before we kind of dig into AB5 and all of the great content we have for you today, I just want to take a few moments to explain who we are and why we are hosting this webinar today. Transforce has been providing drivers to carriers for more than 30 years, from placing drivers directly through our Driver Direct offering to short-term and long-term dedicated placement through our Driver Ready program. In the last few years, we've made a few huge updates to help eradicate the driver shortage. We've purchased CDL schools to help bring new drivers into the industry, including a huge number of veterans annually. And we recently launched a new technology platform called TF1 to help accelerate the recruiting process for drivers and carriers. Over the last several years, we have been heavily invested in the education of AB5 to carriers and drivers, and we want to share that knowledge with you today and help you make the best decision for your company moving forward. We'll go on to the agenda. So for today's agenda, we're going to review what is AB5 and what is the impact. We're going to review solutions for motor carriers to become compliant with AB5. We'll review a brief case study, go over our proposed solution, and we'll have some Q&A, and we have a couple of polls sprinkled in as well. So today we have on our webinar Lisa Mitchell from Transforce. She is our AB5 dedicated solutions specialist. And we have Rick Schweitzer, who's general counsel for the National Private Truck Council. If you're not familiar with NPTC, it's the only trade association in the United States devoted exclusively to the interests of private corporate trucking fleet industry and its professional practitioners. NPTC represents a cross-section of American manufacturers, distributors, retailers, and public service organizations ranging in size from family-owned small businesses and town utility fleets to Fortune 500 global. So we want to welcome Rick and Lisa today. And we'll go ahead and do our first poll. So before we get into our content, if you can just take a few minutes to answer the poll, do your drivers have their own authority? Okay, we'll move on now to Rick.
Okay, next slide, please. Yeah, and this slide begs the question, why are we doing this webinar today? Well, as of about 10 days ago, the US Supreme Court refused further review of a decision of the Ninth Circuit Court of Appeals in a case that was brought by the California Trucking Association that challenged the validity of AB5 and its three-part ABC test on worker classification. And by refusing further review, the Supreme Court allowed the Court of Appeals decision to stand. The Court of Appeals decision had itself affirmed the validity of the California statute on worker classification and refused to preempt it under federal law. So what we're dealing with now is the AB5 statute in effect. And AB5 just refers to Assembly Bill 5. This bill, when it was in legislative form, started out in the California State Assembly, so it was referred to as AB5 as a shorthand way of mentioning it. It has now been incorporated into statutory law in California. Originally, the three-part test, which is the substance of AB5, was developed in a court decision in California with the California Supreme Court. And it reversed the approach of a prior court decision, which was the Borrello case. And I'm not going to get into all of the specifics of what Borrello did and what the subsequent California court case did. But what we have now is a statutory codification of the court's decision that has been challenged in federal court and affirmed. So as of now, the three-part test for worker classification in California is in effect, and it's in effect retroactively to January 1, 2020. That's when AB5 was supposed to go into effect initially. The California Trucking Association's case initially obtained an injunction against enforcement of the ABC test. That injunction was withdrawn by the Ninth Circuit Court of Appeals and the subsequent refusal of further review by the US Supreme Court. So the ABC test is in effect. It's in effect most likely retroactively to January 1, 2020. So let's go to the next slide. What is the ABC test? It's, as you might guess, a three-part test. Part A is, and this is a test that determines whether or not a worker is an independent contractor or an employee. In order to be an independent contractor, you have to meet all three of these criteria. The first is the worker is free from the control and direction of the hirer in connection with the performance of the work. That's pretty standard. The second part, the B prong of this test, is where the problems come in for trucking. B says the worker performs work that is outside the usual course of the hiring entity's business. Well, if you are an owner-operator truck driver, you are most likely providing work that is within the usual course of the hiring entity's business. If you're working in conjunction with a trucking company, you're providing trucking services for a trucking company. If you are a private fleet, on the other hand, where your primary business is manufacturing or retail or some other type of operation, then you have a better argument that an owner-operator would be providing services that is outside the usual course of the company's business. It's not the same as saying the primary business of the company is manufacturing. The usual course of the business possibly could include delivery services, either inbound or outbound. So I'm saying you have a better argument if you're a private fleet, but it's not necessarily a black and white issue here. And then the third part of the test is that the worker has to be customarily engaged in an independently established trade, occupation, or business of the same nature of the work performed for the hiring entity. So if you're an owner-operator truck driver, you are a small business person. You're running your own company. And the company may be just yourself, or it could be several other individuals who work for you or in conjunction with you, but you are in an independently established trade. And again, the worker has to meet all three of these criteria in order to be considered an independent contractor for purposes of this ABC test in California. Let's move on. Okay. So effective June 30th, which is the date that the US Supreme Court refused further review of the Court of Appeals decision, owner-operators have to be classified as employees under California state law. Unfortunately, that's really the short version of all of this. And then how is this enforced? And this is where it gets tricky, because there are really two ways to do this. One would be a suit brought by the California state government. The California Attorney General could bring a misclassification lawsuit against you. And there are also even certain city attorneys who are authorized to bring a government action against you. And there are civil penalties between $5,000 and $25,000 per violation. There are also questions about whether or not the worker should receive unemployment insurance. Obviously, if the worker is properly classified as an employee, the worker is entitled to unemployment insurance. The same for workers' compensation. If you're not covering properly classified employees on your workers' comp plan, there are penalties there. And as I said, they're most likely going to be potential penalties retroactively back to January 1 of 2020. But the other way to enforce this, and I think by far the more dangerous way to enforce this, is through what's known as the Private Attorneys General Act in California. It authorizes individual private lawyers to take on cases of worker classification essentially on behalf of the government. But these are private lawsuits. So a driver could bring a case for worker misclassification against a particular trucking company, and that driver could hire a lawyer to bring the case on his or her behalf, not just for himself or herself, but on behalf of all the other drivers who operate for that company. It's essentially a class action lawsuit. And this Private Attorneys General Act not only authorizes these types of cases, but incentivizes them by allowing for particular attorney's fees for the attorneys that bring this. That is far and away the more difficult scenario that you might face. Next slide. And then what does this mean for other states? Obviously, in California now, the ABC test is in effect. Illinois, New Jersey, Washington State also have ABC tests that have been enacted and have been put in effect. Massachusetts has an ABC test for workers, but in Massachusetts, they brought the same type of court case that the California Trucking Associations brought, but in Massachusetts, the litigants or the petitioners actually won, and they got a decision from the First Circuit Court of Appeals, which is the New England states, holding that federal law does preempt the application of the ABC test to truck drivers. The California Trucking Associations brought that same argument to the Ninth Circuit Court of Appeals and got a different result. Normally, when you have two courts of appeals that have different results, the US Supreme Court is much more likely to accept that case for review in order to resolve the conflict of authority. They didn't do that here. So we have the First Circuit that says, yes, the ABC test is preempted as applied to truck drivers. In California, you say, no, it's not preempted with regard to truck drivers. Hopefully someday in the future, we'll get a resolution of the conflict. But there are other states that have either introduced or considered ABC type tests for worker classifications. And my guess is that now that the California case has at least been resolved for the time being in the courts, you're going to see many other states begin to implement this type of a worker classification structure. So with that, I'm going to turn it over. Well, do we have another poll?
Not yet. Thank you
Not
so
yet.
much, Rick.
Okay.
Before we head off to Lisa,
Yeah.
I just wanted to reiterate to everyone on this webinar today that although Rick represents the National Private Truck Council, the information here today is for all carriers. So just want to make sure that it's not just for private fleets, but for all carriers. And with that, Lisa, we'd love for you to kind of go over our options for motor carriers with AB5.
Good morning, all. Thank you, Catherine. Thank you, Rick. So there's 4 options basically in order to comply with the new AB5 law. Obviously, one is cease business in California, less realistic, especially for large carriers. Convert all your independent contractors and do an employee-employer model. Establish a brokerage, which also can be expensive for the driver and time-consuming, or qualify for the B2B exemption, which is the most rare exemption that people mostly will qualify for. So there are some options for motor carriers to do and comply with the law. Can I have slide 2, please? Or next slide.
Okay. So with that information, let us know which option you're considering. And while we're doing this, Lisa, if you could just go over a little bit more on each of the models as they're thinking about which option they would consider. Can you give us a little more information on each of them while they're considering?
Sure. So converting the owner operators to your, as an employee to your current motor carrier. So that's option one. Utilizing or establishing your own brokerage. It's option two. Obviously, all the drivers have to get their own authority. You have to create a brokerage, keep them at arm's length, qualify under the B2B exemption, which only certain motor carriers in the state have that qualification, like construction or type of carrier that you are, or you're unsure. You don't have any ideas on how you're going to tackle this AB5 new ruling.
Okay, we'll give everyone a few more seconds. All right, next slide. Okay, so for this one, we wanted to mention a quote. Transforce has a great relationship with the Western Trucking Association, and Joe, the Director of Governmental Affairs and Communications, said, for motor carriers with leased on owner operators, the two-check system may well be the best option in my opinion. Converting leased operators to motor carriers with their own motor carrier numbers and operating authority has its own set of complications. Namely, in California, it is very difficult to secure affordable insurance coverages for new motor carriers. Many insurance providers will not write new motor carriers. So I'm going to have Lisa talk about what the two-check system means. If we can go to the next slide.
So before we kind of go into, I wanted to give a little bit of historical data of how we actually got here. Transforce has been working, following this case since 2018, and then waited for it to be codified. We followed through the entire thing. So we recognized this was going to change the way California trucking companies do business in its entirety in California. So we are offering a two-check system in which the driver will get two checks, one from Transforce, as they will be a W-2 employee, and one from the lease back of their equipment. So they'll provide, each driver will get a check from us and the motor carrier in order to have be compliant. So next slide. So here's our program overview. We offer a dedicated solution. Again, with the two checks, we hire them on as employees. You obviously pay them on the leasing of their equipment. We also will help manage additional recruitment, health benefits, sick, PTO, everything that California is required, and also eliminate the workers' comp and UI liability exposure. Sorry, guys. So the 3 steps below, we do a business analysis, scoping and pricing, and then we'll show you how implementation works. And I can go over that and how it works at one of our case studies that we have. So next slide. That's quick. So we have a client named Osterkamp Trucking Group that we've had a long-standing relationship, about roughly 7 years. Initially, when this all came about, I reached out to all of our existing clients to see if they had an option for AB5 and how we can help. So they partnered with us, and we were able to absorb all of their owner-operators as our employees, and they did a lease back of the truck. Now, they had other options, obviously, hiring the drivers direct, but obviously it created them a little more exposure, and they wanted to keep arm's length. Purchasing the independent contractor's equipment, very expensive option, or take the risk and waiting to see if the legislation passed or failed. Obviously, it's current now, so they did, they prepared themselves very well. Can I get the next slide? So one of our solutions was obviously the two-check systems. We converted all 200 independent contractors to our employee. We pay for we help with their benefits, workers' comp, we do the entire thing, because Osterkamp also did not have the infrastructure to do so. Currently, our retention rate at that company is 99%. I know many think the view of drivers won't want to do it and things like that, but because of the health benefits, 401k, things like that, and their pay really didn't change, it is a very good option for those drivers. We have a 1% turnover rate right now. So it's a successful program. In a couple of weeks, we're actually going to have, you want to go back real quick? A couple of weeks, we're actually going to host a webinar with the Osterkamp group, and where carrier to carrier can certainly ask questions. She can explain from her perspective how our program worked, and she can discuss the challenges and successes of what they had. So what are the next steps? Evaluate your options, know your risks, develop a plan, and contact a Transforce expert.
Great. Thank you so much to Lisa and Rick. Again, we are here to help. We are going to send out this webinar and slide deck so that you have links to these additional resources. You can contact Lisa directly. Darren at Osterkamp has also graciously agreed to give her contact information if you have questions about that. And again, as Lisa mentioned, we are going to host another webinar with Osterkamp to really do a little bit of a deeper dive on how that integration took place and more of the details of that. So we'd love to have all of you there as well. Next slide. And then we'll go into some questions. We'd love to hear from all of you. If you have any questions, we are here to answer them.
I'll take this one. Does retroactive effect mean there will or could be penalties for non-compliance back to January 1st of 2020? Unfortunately, yes. The fact that this was enjoined in the court from going into effect after January 1st of 2020 doesn't preclude the possibility of either penalties from an attorney general action or damages in a misclassification private attorney general lawsuit back to then.
So the next one is, how will this affect brokers? Rick, do you want to take that one as well?
Yeah, I don't think brokers in particular have any liability exposure here. Brokers typically are not hirers of carriers or of drivers. Brokers are intermediaries. They're not an agent of the carrier. They're not an agent of the shipper. It is the carrier who stands to lose by having the owner operators declared employees of the carrier.
Thank you. Okay, next question. I think, Lisa, this one will be for you. Under your two-step program, the owner operator's equipment would be under an agreement with the motor carrier. So would they would be able to continue using their own equipment? How does that work out with maintenance? Would it be the MC's responsibility?
So maintenance is typically the owner operator's responsibility, as always. So yes, they would enter a separate agreement with the motor carrier direct in regards to maintenance requirements, because I know that we still have bit inspections and that sort, but that is between the carrier and the driver. But yes, you'll also have a lease with that driver directly.
Right. Let's see, speak to broker only model and degree of control by transportation broker and dispatching carrier with its own authority. We got to that. If I'm leased to another company, how long do I have to get my permits without having any penalties?
So when the law is enacted, is enacted. So unfortunately, you will have and can possibly incur fees the day until you get your complete own authority.
Thanks, Lisa. To start a brokerage and broker only your own work, is that an issue?
You are allowed to do that, but you do have to have separate broker authority from the Federal Motor Carrier Safety Administration.
Okay. Next question. It seems like the federal court in San Diego may have further review on this AB5. It is not final yet. Is it not final yet? Do we have information on San Diego?
I don't have any information on that particular case, but it is final as of now, in the sense that the injunction has been lifted and it is being enforced by the California Attorney General.
Okay.
So it will go back to San Diego court, but obviously if San Diego accepts it or not, it will be definitely declined by Ninth Circuit. So yeah, it's certainly a long shot that this will be retracted in any sort.
And which regulatory agency will mostly be enforcing AB5?
Unemployment.
Yeah. It's essentially a labor code violation, right? Yeah.
Okay, if I have a trucking company and I hire, and I think this is saying in North Carolina, and I hire a California driver as an independent contractor, will I have to abide with AB5?
To perform,
so it's not really, I'm sorry, go ahead, Rick.
I would say to perform services outside of California, I think the answer is no. Even if the driver is based in California, if all of the services are outside of the state, California is not going to have any jurisdiction over an out-of-state company.
So they measure it in time as well. So it really depends on how much time you're spending in California. If 90% of your time is in California delivering, and then you go out of state, maybe a day a week. So it's measured in times. You'll have to figure out how much time qualifies.
Mhm.
It's not necessarily because of where they're domiciled, as Rick stated.
Yeah.
Okay, next question. If an owner operator has 1099 drivers, but the owner operator goes through a broker, are they in compliance, or would each individual 1099 driver need to be set up as their own carrier working with that broker?
You know, I could see an argument where you would have to have the owner operator who was in control of this and issuing those 1099s could be considered an employer of
Correct.
those other drivers. Yeah.
So the 1099 carrier would have to be an actual motor carrier, have his own authority, but he's also an employer. So anyone under him has to be on someone's payroll, which would be him.
It's just like a large common carrier,
right?
Having
And that's how it would be
drivers.
viewed.
Yeah.
Correct.
Great. Our company is a brokerage with no assets and the same owners, having a trucking company that bills the brokerage for the transportation. We also have owner operators that bill the brokerage. So are we okay?
To the extent that you're using a bona fide broker to handle your shipments, and the individual owner operators have operating authority and are considered for hire motor carriers, you'd be okay.
Is it required to pay drivers with a payroll check under this new change? As a broker, what will make us compliant?
Well, again, I think the key there is to have owner operators who have their own for hire motor carrier operating authority. They're not going to be considered your employees then.
Now, I know there's a lot of brokerage questions, and advice to the brokers: certainly follow up and keep updated on the law. Lorena Gonzalez, the Assemblywoman who started all this, did say that eventually brokers would have to meet the ABC test as well, which B is the problem.
Yeah. And as we said at the outset, please don't accept this. I know I am a practicing attorney, but don't accept this as the last word on any of this. Please consult your own competent legal counsel who has experience in worker classification issues when you're planning your own operations in California. I can't stress that enough.
Thanks, Rick. Other than the two-check approach, does TransForce offer any other services or solutions for the independent contractor or owner-operator that already is a corporation, has its own authority, insurance, etc.? So
this program on the AB5 program on dedicated solutions is actually only geared to those. So we're not a brokerage. We hire drivers, we recruit candidates, and those candidates would just be in our employ. So we don't have current opportunities like that for owner operators to split. Now, doesn't mean potentially we will, because we do have a lot of clients in this program as well, in which we can slip seat them to carriers.
Let's see. Okay, next question. What about motor carriers that have sub-hauler agreements with other motor carriers with their own authority, insurance, permits, workers' comp, own employees they pay? They will be hauling our goods. Do these agreements still fall under this AB5 law? They are in contact with our team for updates, but that is the only communication under control.
Yeah, if you have a motor carrier subletting some of the trip to another motor carrier that again has its own authority, then the first carrier should not have any issues with AB5 under this.
Right. They just have to have their complete own authority, their own insurance, and they have to
Right.
be a motor carrier. Absolutely.
Great. We have 2 sections here for questions. Let's see. How likely is this decision to be overturned?
Not very, frankly. And if it were to be overturned, it would not happen for a number of years. So I think you have to accept that this has gone into effect and will likely remain in effect for quite some time.
Agreed. And certainly make your business decisions as quick as possible to
Yeah.
lessen your exposure.
Okay. And someone asked how we can get the video of this. We will be sending this out to every attendee today. Let's see. How can organizations assist their drivers that are members effectively become compliant, especially their members with language barriers?
Wow.
So it depends. It obviously depends on what route you're going as well, right? So you can assist them to get their own authority and things like that. But to be perfectly honest, because of this new legislation, the getting your authority is not as easy as it used to be. Obviously, getting your own insurance is not as easy, and there's a backlog. And a language barrier, Rick, what do you think?
Run programs in Spanish. It's the best thing I can say.
Yeah.
That's the same as any other compliance information that you provide to drivers who don't use English as a first language.
Great. Let's see. What if you are a broker and a carrier and you are selling your trucks to the drivers and they run under your authority? Are they considered your employee even though they are buying the trucks from us?
Yeah, I don't think buying the trucks from you necessarily gets you out of the possibility of classification as employees. In particular, if they are providing truck driver service to you as a motor carrier, you're not going to be able to meet the B portion of the ABC test.
If I have my own authority in California and DOT, will I be able to keep as an independent contractor?
I think, yeah, definitely.
Especially if you run under a brokerage, absolutely, you still have that option.
Yeah, you are a motor carrier at that point.
Right.
You're not an independent contractor leasing yourself to a for-hire or private carrier. You are a for-hire carrier yourself. So you have to have your own insurance and your own billing and collection functions and sales functions and such. But yeah, you will be an independent contractor.
Now, if you have drivers under your authority or working that way, then they would have to become your employees.
Yeah.
Okay. If I have an out-of-state independent contractor and provide for delivering a load to California and a return load from California, does the return load cause a problem?
Not necessarily. I mean, you don't automatically fall under AB5 the minute the driver crosses the state line from out of state. The question in my mind is, what if that out-of-state driver picks up a load in California and takes it to another place in California?
Right.
Again, I don't think a single intrastate trip is going to subject the driver to this worker classification scheme, but at some point it will. And it's a matter of degree and percentages. There are cases, for instance, in the airline industry where out-of-state airline employees who work on flights intrastate in California have fallen under the California labor code. So, at some point, the answer for intrastate travel in California is yes, your driver would be subject to this worker classification regime. Just going into the state, dropping something off, picking up something from California and bringing it back out of state, I don't think is going to subject you to this.
Thanks, Rick. Let's see. Do you have the PowerPoint in Spanish? We do not currently, but that's a great question. If there's a big demand for that, we can certainly look into translating that to Spanish for those who need it. Let's see. Can a trucking company with employees broker owner-operators for trucking?
I'm sorry, say that one again.
Yeah, I couldn't hear you.
Yeah, can a trucking company with employees broker owner-operators for trucking?
Does the trucking company own their own brokerage? So I'm a little confused on that.
Yeah.
Yeah.
Oh, wait, maybe this is the same person. She said yes to your question, Lisa.
So if the motor carrier owns their own brokerage, the same rules apply with everyone under that brokerage has their own authority and has the ability to work at other brokerages. So the issue is controlled, right? So they have to have the ability to work at various locations. They all have to have their own authority in order to comply.
Yep.
Okay. And then here's another request for this information in Spanish, so noted.
Also, if
And
anybody wants to have a conversation with me one-on-one, I do speak Spanish as well.
thanks, Lisa.
Sure.
Okay, and then does Transforce provide the truck insurance?
No, that's up to the actual driver, as he is the owner, he or she is the owner of that equipment. So they're responsible for that.
Great. Any other questions? Can we have Lisa's direct number?
You have my email?
Yes, we do have Lisa's email in this presentation again that we'll send out, and you can contact her and set up a time to speak with her. Absolutely. Okay, if the permits are under my name and I don't have a corp or LLC, do I need to get one?
So for this, it is recommended that you get your S Corp, and LLC would do as well. However, again, it's getting all the operating authority. You now are a motor carrier, as Rick stated.
Great.
There are other good reasons to have corporate status as well, to limit your liability, but so that your personal assets are not at stake. But the key is to get your own authority, and with that, your own insurance.
Right.
Okay. Anything else? Does anyone have the last call for questions? Okay, Lisa, this one is in Spanish, so if you can read the chat.
I think if I can click on the chat, I have to go back.
Yeah.
Can you see it, Lisa?
Yeah.
Scroll to the very bottom. It's from Yesenia Teo.
Yesenia? Yeah, I'm trying to. There's a lot of messages in here. You can read the next. I'll chat her back right now.
Okay. If you pay employees and own your fleet of 2 drivers, do you still fall under AB5?
Well, they're already employees, so well, you have no additional liability under AB5.
Is PAGA, PAGA, the biggest threat?
That's the Private Attorneys General Act that I mentioned. And I think the answer is yes, simply because you're more likely to have a lawsuit filed against your company by a private attorney who is representing one or all of your current and prior employees. The California Labor Department, represented by the Attorney General, also has authority to bring in a regulatory enforcement action against your company, but they have much more limited resources, and every private attorney in California is authorized to bring these cases under the Private Attorneys General Act.
Thanks, Rick. This one says, I do have motor carrier California DOT and my own insurance and my corporation. Can I work with any other carrier and be compliant with AB5?
Yeah, I think that's a very good start. You are a motor carrier, so you should not be considered an employee of any of your customers.
Great. All of our subhaulers have their own authority, insurance, etc. We have been told that they have to be employees. Is that true?
I'm sorry, say that one again.
Sorry, all of our subhaulers have their own authority, insurance, etc. We have been told they have to be employees. Is that true?
Are they
The
running
question,
with you direct? I'm sorry, go ahead, Rick.
yeah, I mean, the question would be employees of whom? The sub-hauler's got a question as to whether or not those drivers are their employees, but you, as another carrier who is subbing out some of the work to that other motor carrier, no, that's not your concern.
Great, thank you. Do you think workers' comp insurance providers will seize on AB5 to call all carriers working for your employees, even if you are a broker only?
I don't know, to be honest with you. It's hard to speculate on what workers' comp carriers are going to do.
Okay. Let's see. Working with a hybrid company that has both carrier authority and brokerage authority, and they make the appointment for us to pull loads from the port, will we have a conflict?
Yeah, I'm not sure on that either. I don't
Yeah.
know if you would have a conflict for both. I'll have to think about that.
Okay.
Okay.
With an LLC, DOT, California DOT, and MC, will I be able to operate as an owner operator?
I apologize. Read that one again, Catherine.
With an LLC, California DOT, and MC, will I be able to operate as an owner operator?
Yeah, as long as you have your own authority and run
Yeah.
through an entity, you'd still be able to run as an owner operator, just not directly for a carrier.
Yeah, I mean, the difference is if you have your own operating authority and obviously insurance, then you are a motor carrier. You are the same as JB Hunt or Schneider or some large motor carrier. And you are contracting with shippers directly or through a broker to provide motor carrier service. The typical owner operator model, at least up to now, would be not to have your own operating authority, but to lease yourself to a carrier or a series of carriers. And you'd be considered an independent contractor, but you weren't necessarily a for-hire motor carrier. You were operating under your shipper or other motor carrier's authority. You can't do that anymore in California. If you're the owner operator, you have to have your own motor carrier authority and operate as a for-hire trucking entity.
Okay, we have a small private fleet with employee drivers. We also have one owner operator pulling our trailers with his own authority and insurance. Sounds like he is good. We also hire outside fleets and owner operators to fill in during busy times. Sounds like they are also good as long as they have own authority and insurance.
I think those are fair statements.
Okay. The next one is, so essentially anyone 1099 under their social will fall under AB5, but not those with a TIN, correct?
With their own authority, not working directly for a motor carrier.
Okay.
Yeah.
Let's see if I can. In California, the owner can be excluded on workers' comp. If the owner operator owns their own truck, do they still need workers' comp?
So, I mean, I know there's ad hoc, right? So ad hoc is certainly a good protection if they're still qualifying under their own authority. Because I'm pretty sure getting your own authority would require ad hoc insurance. But I certainly can find out.
Here is Nancy is asking, can you please touch up on the question Yesenia asked about having her owner operators incorporate to not pay them with 1099? This is the one that was in Spanish, Lisa.
Oh, I just texted her, but yeah, I guess the question was if they're running under her authority, if the owner operator has their own MC, DOT, and insurance, do they need to sign a separate concession agreement? I think I just read the last one. Reread that one again, Catherine, please.
It says, could you please touch up on the question Yesenia asked about having her owner operators incorporate to not pay them with a 1099?
So if they incorporate, they still can be paid with 1099, right, Rick? I mean, having your own authority and doing a corporation, you can still pay them with a 1099.
Yeah, sure.
Mm-hmm.
Thank you. Let's see. Okay, here's a question. How will it be determined? I think this is what they're trying to say here. So I apologize if not, but it looks like the question is, how will a carrier be found that he is on violation of AB5?
Well, there are a couple of different ways. One, you get an enforcement action either from the unemployment insurance office or directly from the California Attorney General's office. More likely, you get sued in court by an attorney on behalf of one or more of your drivers for misclassification of your workers as independent contractors. There's no one's going to come and do an audit of you and say you are not in compliance. You can do your own audit using the 3-part test and make sure that you are in compliance yourself. But the way you'll find out is either you get sued or there's an enforcement action brought by the California state government.
Thank you.
So a proactive approach is best.
Yeah.
Let's see, next question. Will I need to get an LLC or just a DOT, MC, and insurance?
I would say the DOT, MC, and insurance is the minimum. The LLC is not absolutely required, but it's a good idea to have it anyway.
It's an additional protection.
Yeah.
So getting your own authority is just those 3 steps: insurance, MC, and DOT number. And the LLC, S Corp, or whatever you choose, just gives you an additional protection, like you said, for personal assets.
Mm-hmm.
Okay, so just to clarify, because there's another question, defining own authority. So that's the DOT, MC, and insurance?
Right.
Yeah, you register with the Federal Motor Carrier Safety Administration if you're an interstate carrier. And you get a US DOT number, which is basically their safety database, but you also get an MC number, which refers to motor carrier, which means that you are a for-hire motor carrier. And it's a very simple application process. It costs $300. Takes a couple of weeks to get a response back, but then you also have to have liability insurance that's on file with the FMCSA, and you have to have agents for service of process in all 48 states as well.
Okay, next question. Do owner-operators need to make their own appointments at terminals?
I don't think so. I don't really think that plays into this worker classification issue.
Right. I don't think so either. It's just kind of a different topic.
If an owner-operator has their own MC, DOT, and insurance, do they need to sign a separate concession agreement with the LA port?
That I'm not sure.
Okay.
Yeah, I don't know what the concession agreement with the port would do. With regards to working for a carrier or a shipper, it makes sense to have a motor carrier contract because you're a for-hire motor carrier, and it's better to have those contracts in writing. Yes.
Okay. I have apportioned California plates and I'm leased to a company that's outside of California. Is that still okay?
Yeah, but it is at this point. If you begin operating the majority of your time intrastate in California, it might become a problem. But an occasional trip into California and picking up something and bringing it out of California should not subject you to AB5. But I can't say that definitively, and I'm not exactly sure where that bright line is.
Great. Next question. If you are intrastate, do you still need MC?
Yes, you'll still need your own operating authority.
Okay.
Yeah, but you get it from the state of California rather than Federal Motor Carrier Safety Administration.
Correct.
Great point. So will I still be able to get loads from brokers or load boards, but not from a transport company? Is this correct?
Yeah, so load board is obviously referring to a brokerage. Again, as long as you have your own operating authority, it should be fine.
And this is a clarification question. If the 1099s have their own authority and insurance, does that violate Part B of the same work, or does it pass the test and is not in violation of AB5?
You are a motor carrier at that point. So you are contracting with a shipper or another motor carrier, and you should not be subject to AB5 at that point.
Okay. That was the, oh, is the brokerage part required in between?
No.
Okay.
No, you can be a motor carrier and contract directly with a shipper or contract directly with another motor carrier as a subhauler without using a brokerage and still protect yourself from employment status. The key is to have your own motor carrier authority and insurance.
Okay. I think that's it. I'm just double checking because we have questions coming in from the Q&A section and chat. So just a second. Okay, we have a trucking company with our own operating authority with W-2 employees. We hire owner operators with their own operating permits authority, but a few don't have workers' comp. Well, I need to pay those as an employee.
So your motor carrier that utilizes directly all drivers that have their own authority, and then you have one that doesn't have, or some that doesn't have at the minimum ad hoc, you'd still be considered as an employer if it's direct. Now, if you're going through a brokerage, I just need a little more intel on your question.
Okay, we'll see what they answer. Let's see. Here's interesting. What do you think would happen if every owner operator in California went on strike for a week to show disagreement against AB5?
So unfortunately, that's probably unlikely, and it's not going to change the law. I mean, it kind of is what it is at this point. We understand completely. People are absolutely disgruntled, and rightfully so, but it's certainly not going to just change the law or push the law towards them putting another stay.
That is a great point. Okay. Okay, so the follow-up intel on the last question is they are not required to have workers' comp because they don't have employees.
I'm still a little
Let me read
lost.
the first one again. It says we have a trucking company with our own operating authority with W-2 employees. We hire owner operators with their own operating permits and authority, but a few don't have workers' comp. Well, I need to pay those as an employee.
Yeah, so that's the issue. You definitely would have to pick one of those four options, run them through a brokerage, obviously not do business with owner operators, or employ them.
Okay. Let's see here. I was told by Scopolitis that I have to get a broker's license to contract with my subhaulers after they get their own authority. Is this true?
I would definitely probably take the advice of Scopolitis.
Yeah.
And certainly consult your attorneys.
Okay. I think we've answered everything.
And certainly everybody, you still will get my information as well if you continue to have questions.
Okay, we have a couple more minutes. If there are any last questions, give a couple more seconds. Okay, well, I want to thank Lisa and I want to thank Rick so much, and thank all of you for tuning in today and joining. We appreciate it, and we hope to see you on the next webinar. And please reach out to Lisa with any questions, and have a wonderful day.
Thank you,
everyone.
Thank you all.
Thanks, Catherine. Thanks, Coco. Thanks, Rick.
Yep. Bye-bye.
Bye.